Good afternoon, ladies and gentlemen, youth diggers, EuroDIGers. Welcome to the very last panel session tackling online harms, a regulation minefield, present and future. I'm Virginia Balciunaite. I'm an advocacy officer within the social enterprise Sunium, and I am more than happy to invite you to this discussion. And it's also my utmost pleasure to host this discussion and look at the future of regulations that are being developed in different stakeholder fields. That's why we have this very different but very engaging and impressive plenary session today. And to begin with, I would like to outline how we started the session. So we built up the session by trying to map out all of the social harms, online harms that are out there. Our organizing team mapped out over 250 online harms. And we only looked at the European documents, and we only looked at our expertise and our experience. And then we decided to look at the future. What does it hold for us? And because also the future is messy. It looks messy, it feels messy. And also, let's face it, regulation takes a long time to be voted and implemented. Then it's also important to have this debate now that is anticipatory. And we need to include visions, viewpoints, and knowledge, not only from researchers, scientists, but also from stakeholders who have the possibility to look a bit in the future and share the knowledge with the legislators. So looking into the future, we raised several concerns, and therefore we invited four key panelists, key participants, who we believed are going to address these concerns and the future that they perceive. So firstly, we wanted to see the current developments. So we invited Professor Lorna Woods from the University of Essex, who has extensive experience in the field of media policy and communications regulation, including social media and the internet. And we wanted to address recent policy developments in the United Kingdom because they have recently published an online harms white paper which sets out the government's plans to keep the UK safer online through legislative and non-legislative measures. Secondly, we wanted to see why we're falling short on the human rights aspect. So we invited Jan Kleijsen, Director of the Department of Information Society and Action Against Crime, that focuses on Council of Europe's work on the media, information society, and for action against crime. Thirdly, during our team meetings, we also raised the concern for the future of technology in relation to online harms. We said that telecommunications and internet services providers should be here to talk about the future for regulation. So we brought Chris Buckridge, who is External Relations Manager for the RIPE NCC, and his role involves engaging the broad range of RIPE NCC stakeholders, including members, governments, law enforcement agencies, and international organizations. And finally, it's my very pleasure to introduce to you a EuroDIG fellow, Ms. Neri Bagdasaryan, a human rights lawyer at Ara Gazarian Law Office in Armenia. So I introduced you four different speakers, but also would like to introduce to you different sessions that are directly related to this panel. Therefore, I would like to invite you, Michael and Alana. Michael Ogia, he worked with the workshop titled Fending Off Trolls Journalists in Defense of Democracy, and Alana Perotti was from workshop 12 titled Play the Villain, Learn to Fight Disinformation with News Literacy.
Hello? If it's okay, I'm just going to speak from the floor. if that's fine. So, as she said, my name is Michael Ogia. I'm one of the co-focal points for one of the earlier workshops that we had. WS8 and WS12 both fed into this workshop. And WS8 was focused essentially on the threats to our information ecosystem, such as trolls, disinformation, etc., and how journalism can strengthen it. And although you'll obviously be able to read the key messages when they come out, some of the really major points that we discussed was that disinformation, for instance, is a phenomenon that is evolving quickly in quantity and quality. And some solutions from institutions, such as the EU Commission, include a rapid alert system to timely flag disinformation, the creation of a shared platform between the EU and member states, and the implementation of voluntary codes of practice for online platforms. Our workshop actually included a representative from Google, someone from the Council of Europe, a representative from the European Broadcasting Union, a representative from Internews Ukraine, and was moderated by, and also a representative from the European Commission. So we had many, many different views on this. But one thing that definitely came out was that, for instance, the sustainability of journalism and news media organizations is one of the key problems facing some of the current challenges online, especially disinformation, because if we want our information ecosystems to be more robust, if we want them to include more factual information, one of the best ways to do that is to support good journalism and support fact-based evidence and fact-based information. So that is something that those are some of the major points that we covered, and I'll stop there and move and give the floor to Elena.
Thank you. I don't seem to be able to take this out. Oh, yes, I am. Okay. Hello, everybody. As was correctly stated, I was a focal point for the workshop 12, where we tried to understand disinformation from the inside, from going behind the lines of the misinformation crisis. We played a game that was called the Bad News Game, and that allowed us to see how, to have a little hint into what goes through the process of creating fake news to a specific aim of manipulating public information. I would say that, again, you will read the messages the official way and so on, but I would say personally that there were two specific takeaways from this workshop. Number one, we all need to collectively stop talking of fake news. Fake news is a term that stopped having any meaning the moment that it started being weaponized in order to, again, create propaganda and conspiracy theories. That is really something extremely important. We should start indicating, using terms like disinformation, misinformation, propaganda, hoax, not fake news. Fake news is, as we could see, is being used right now normally to attack journalists when they do the work that they're supposed to be doing, which is holding the powerful to account. And by definition, a democracy should refuse that as a first step. The second very important thing that came out of the workshop was that media literacy and news literacy need to go hand in hand. News literacy is important because it is a way to, it conveys importance to teach to everybody how to understand that a certain piece of news is actually news. And media literacy is important instead to make sure that you have the technical means to navigate the information society, at the same time to recognize what news is not. So that would be our 2 points to participate in this conversation.
Perfect.
Thank you.
Thank you very much, Elena and Michael. And before I give the spotlight to the speakers, I would like to introduce another participatory element that we will have for the audience to engage with us. It's Menti tool. Could we have the page, please? Yes. So through this tool, we would like to get your answers and your concerns about online harms. So please, throughout the whole session, give us your feedback. And your answers will be visible also here, so the speakers will be able to address accordingly. So, and now I would like to give the floor to Professor Lorna Woods. Could you please share with us your insights about the UK legislation procedures and the white paper as well?
Thank you very much, and thank you for inviting me. I'd like to start about 18 months ago, and not with the white paper. I'd like to start by mentioning a research project that I was involved with Carnegie UK Trust. And we were looking at this question of how can we do better? And we thought the problem was that a lot of the debate had been framed in terms of discussing whether social media platforms in particular were publishers or intermediaries. And we thought that that really didn't fit what social media did, the range of activities that are carried out through, on, in social media. So we had a look round existing regulatory models and happened upon something called the Health and Safety at Work Act. What's this got to do with the internet? Well, we thought a better analogy, rather than publisher or intermediary, would be public space. And we noticed that the Health and Safety at Work Act requires employers to make the workspace safe. This is things like fire extinguishers and making sure that the stairs are well lit, that sort of thing. And we thought you can apply this to certainly social media platforms, maybe the internet more generally. Because what you're looking at there is not content, but the systems that the social media companies or other intermediaries provide. And, more particularly, the way they nudge us towards certain behaviours, reward certain behaviours. Do they actually think this through when they release them? Or are they just focused on how this is going to improve the bottom line? So our thought was that we should borrow the idea from the Health and Safety at Work Act that social media platforms should have a statutory duty of care, at least to think about the systems that they put in place. Now, this mightn't be a complete solution, but it may help. Let's move forward a year to the white paper. And that also suggests a statutory duty of care. Now, it doesn't go into too much detail about what the statutory duty of care looks like, but it does refer to safety by design. So I think that there are some similar ideas in there, that the core of the white paper is about how systems are set up. Having said that, we look towards the end of the white paper, and the government's proposing a lot of codes of practice. And some of these are quite focused, and they do focus on notice and take down and how fast that should be. But those notice and take down provisions, requirements, are focused towards the harder end of harms, so things like child sexual abuse material and terrorism. And you don't see it so much when we're talking about, say, cyberbullying and that sort of thing. So the white paper is under consultation. We don't know what the final form is going to be like, but I think that at least part of it is going to be looking to the systems that the companies put in place, even if there is still some concern about notice and take down. The government is thinking this is not just self-regulation, it is also proposing that this should be enforced through a regulator. So I think that's an overview. I can answer questions later.
Yes, we will have a brief 15 minutes for audience engagement, during which people will be able to give commentaries and questions. Now I will give the floor to Jan Kleijsen, please, for your intervention.
Thank you very much. Good afternoon, everyone. Representing the Council of Europe, it will not be a surprise for you if I say that our starting point is the European Convention on Human Rights. And the constant case law of the court that the rights and obligations that apply offline should also apply online. Now, on harmful content moderation. It is, because of the convention I just mentioned, clear that it is the responsibility of states, in the parties to the European Convention on Human Rights, which is 47 European countries, to ensure that freedom of expression is guaranteed, but that the rights and responsibilities that come with that are also respected, and of course that no harm is done. In addition to states, the RUGI framework on business and human rights draws our attention to the fact that companies also have an obligation. In Europe, we have seen that sometimes companies, or perhaps not more than sometimes, companies have not always reacted as fast as they could or should. It is also clear that the terms and conditions of most service providers are not examples of clarity and non-legalese. I don't know how many of you have actually read all the terms and conditions of any frame or platform you're using, but has anyone read the terms of conditions of, say, WhatsApp or Instagram or Facebook, all of it? So that's 2 people there. Well, exactly there. We are 3, 4 out of 100. So that, of course, it's already clear that most people don't realize what these terms and conditions are. We've also seen in Europe that when things go wrong, certain governments are quick to legislate. Germany now has very clear legislation on the responsibilities of providers to take down harmful content. The law is in force. Fines have not yet been imposed. I was at a conference in Berlin 2 weeks ago where the Ministry of Justice pointed this out, but there are very substantial fines that are possible because there is a clear responsibility on the part of industry. Now, you will also have heard of the Christchurch Call, under which industry has committed to take a number of measures following the horrific events in New Zealand. It is clear that the commitments taken in the Christchurch Call will be easier to implement by bigger companies than the small ones. I think this is something we should keep in mind, that for a number of, and it also goes for the German law, and I don't know to what extent the UK white paper will deal with this, but smaller companies may have a tougher task in complying with very short deadlines. What is also clear is that algorithms will play a big role in removing harmful content, given the speed and scale. And let's take Christchurch as an example. It is clear that human moderation will not be able to avoid harm. Therefore, algorithms will be used. And I would like to pick up a point that was made by the youth diggers a moment ago. It is, of course, important that these algorithms respond to certain criteria. Now, at least 47 governments must already have been informed of what the youth dig came up with, because the proposal that was made to harmonize the ethical rules has been taken up 2 weeks ago and has been taken even a step further. 47 governments have decided not only to align the existing 60 or so ethical frameworks that exist, but to start working on a binding treaty distilling the essential principles of these 60 ethical charters into law. So that is important, and it will hopefully ensure that when algorithms are used, and algorithms are used not only for content moderation, by the way, but for internet governance more and more in general, that these algorithms also correspond to certain criteria as regards transparency, and that a human rights impact assessment has been made. Finally, I would like to add something on the human rights of the human moderators, because I think that is a subject that is not often mentioned at conferences. Some of you may have seen the film The Cleaners. A book has just been produced on the human content moderation, the people that have to do the dirty work. We know, sadly, that the richer world has the tendency to dump toxic waste on poorer countries. I think we should ensure that we don't dump toxic virtual waste on these countries in addition. Thank you very much.
Thank you very much. And now we will have a brief minute just to see at your answers to the question, why do you think we are falling short in addressing online harms? We have 24 participants. That's very exciting. And there are many answers, such as freedom, not the right politicians, little political will, not sure we are actually addressing badly. Slow lawmaking, actual knowledge. A lot of different answers, a lot of interesting answers we could also keep in mind for the future discussion. And now let's go back to Chris. The floor is yours.
Thank you. Well, I'm not going to fix the right politicians problem. I find myself somewhat oddly placed in this discussion, which is necessarily about social media. It's about a lot of the content that we find online that can be dangerous or harmful. The organisation that I work for, the RIPE NCC, manages registration, distribution of IP addresses. So the addresses that internet service providers obtain from us and then use to build the networks. On top of those networks, run social networks, run the content that we're talking about. But we're very clear as an organisation and often as a community to say there's the infrastructure, there's the technology there, and then there's the content on top. And the governance of those two things is fundamentally quite different or requires some different approaches or at least different considerations. That said, I think there's obviously connections that can't be denied, and there needs to be a discussion about the intersection there. I think, Dr. Woods, your points actually sparked two things that I think are really interesting. The first was your initial point talking about the need to scope the problem, and I think that's something that's really, well, important but also devilishly difficult a lot of the time, is actually understanding what the problems are and what the solutions might look like. I think the other point that really resonated with me was that what you turned to was a lot of existing law. And that's something that I think too often is maybe forgotten or overlooked, that maybe the solution is already there in law, and maybe regulation or activities that try to interfere with the fundamental structures of the internet are more damaging when there are solutions that might be found in the law in any case. But I think going back a little bit to the scoping the problem issue, one of the key points that brings me to is the need to understand these things, and that's where that idea of enhanced cooperation and stakeholder groups working together really becomes fundamental. I think in the RIPE community, what we've seen over the last 10 years is the development of closer relationships and more involvement of government, regulators, law enforcement, and a big part of that has been helping them to understand both the technical issues and the technical scenarios and situations that our community is dealing with, but also the policy processes that are available to everyone, so including to regulators and to law enforcement, to have some effect in that space. And we've had some success, well, I think what I would call success in that in the last few years, where we've actually had Europol working with community members, bringing in policy proposals to that RIPE community policy process to make often quite small changes, a small change to how we as RIPE NCC validate an abuse contact in a registration record, but that can have, or at least cumulatively, can have a significant effect on how regulators or law enforcement can try to address at least the bad actors aspect of online harm, so the people who are actually trying to do some of the damage that's been done there. So that's probably my opening perspective on this.
Very nice. Thank you so much. And now, final intervention from my dear EuroDIG fellow. So what's your opinion?
Yeah, thank you. Here representing the youth perspective and also being a legal professional from the Caucasus and also Southeastern Europe, I should start by saying that we believe that this is a multidimensional issue, and just imposing more regulation would not solve the issue. in its whole. For instance, in Armenia and in a lot of countries in Southeastern Europe and Caucasus, there are a lot of issues with regards to regulation because the states are not providing enough, like minimal human rights protection with regards to online harms. For instance, right now in Armenia, there are discussions about draft law on hate speech, or there are a lot of issues with regards to intermediary liability, even though there are two human rights Strasbourg court cases with regards to intermediary liability, but still the situation in practice is not really resolved. And then you have the big internet platforms where there are only the rules that are created not by the community but by the platforms themselves, and people from, for instance, these regions have little or maybe no avenue towards resolving the application of these rules in their particular cases, because the communication with these platforms may take a lot of time, may be costly, sometimes may not end with any fruitful result, and people give up. So in my opinion, this may be a chilling effect on people expressing themselves, or like trying to challenge different harmful content, for instance, online. But on the other hand, we have people that will see that there is impunity in a way, and more online harms will take place in the on the internet, and this creates another issue in these countries where the political situation is, I can say, a bit fragile. And for instance, in Armenia, after the revolution that happened last year, I mean, the internet and the platforms were used in very interesting ways, but right now I see a lot of hate speech that is all over the place, and there are no tools to really fight it, and this creates a polarization and radicalization in the society, which is not something that we welcome. So to sum up, I think we don't need over-regulation, but we need to tackle provide minimal regulations, and then have extensive and effective communication and dialogue with the technical community. And also what I forgot to mention, which is really crucial, and we also highlighted it in the youth messages, is the level of low level of digital literacy, because people, especially in my region, cannot tackle the issue of misinformation enough, and there are a lot of debates with this regard, and this is used a lot in for propaganda reasons, and I believe that this issue of online harms should be really tackled from multiple angles. As I said, with regards to minimal regulation, not over-regulation, dialogue among the stakeholders, and of course initiatives towards raising the digital literacy.
Excellent. Thank you very much, Mary. And now I would like to invite you all to question and raise concerns and to what was said previously. So I now open the floor for you. There are 2 microphones in front, so please raise your questions and come up to us to ask questions. And just to start the initiative, the discussion, I would like to go back to EuroDIG messages, because one of the messages was that we should create the curricula and enforce it by regulation. And I would like to ask you, our dear speakers, participants, what is your opinion about it? What are your thoughts about enforcing curricula through regulation?
When you mean curricula, you mean content online? What is
In schools.
In schools. Well, on something on digital literacy and enforcement here, in most countries, as far as I know, children get some form of traffic education when they go to school, because quite rightly, both authorities and parents assume that it is safer that the children know the code de la route, as the French say, the highway code before they go into the traffic. On the digital highway, no such training is systematically provided. And one of the main concerns, and I couldn't agree more with you, is that the literacy digital literacy is generally lacking in schools, but also in other categories, elderly people, for instance, people with disabilities. There are lots of people who are excluded from the digital mainstream, and therefore I think there is an obligation, and we hope that in this instrument on algorithms that we will negotiate, there will be an obligation included for states to ensure that digital literacy is promoted so that people know. I was at a conference recently of prison directors, and it was about AI and prisons, and asked how many of you have been using an AI application or have been interacting with AI in the past days. And out of 150 people, only 2 raised their hands. So I asked them a question whether anyone had used a mobile phone for the past few hours. But it just indicates how little people are aware.
I was just going to say the white paper does have an admittedly very short section suggesting that digital literacy is important. It builds on existing media literacy, and the media regulator in the UK does have media literacy obligations, which is good. I would just like to say that media literacy, when people talk about it, they do focus on users as victims, how to avoid being abused, that sort of thing. And that's important. But I think it's also important to remind people that they shouldn't be bullies either. And going into technical education, to actually get the computer scientists and those sorts of people to go beyond doing one lecture on the GDPR and to say, think about what you're building and how you're building it. Because a lot of things are built these days by taking from a library of software. And who knows what's buried in that library of software?
If there are no more comments, then I would like to take the question from the floor. Could you please also say your name and affiliation?
Sure. I'm Colin Curry from Article 19. When we think about ethics and well-being and different conceptual frameworks for evaluating what is right or wrong or good or bad, I know in our organization when we were engaging, for example, in the IEEE's global initiative on the ethics of autonomous systems, one of the things that we pushed back against was use of well-being or ethics as rubrics for evaluation, just because ethics can be contextual based on the sector or the environment, and then well-being can be incredibly difficult to gauge even if you're checking on your own well-being. So we were always pointing back to human rights frameworks as an appropriate standard to evaluate as appropriate rubric because of its corpus of international law and binding treaties, things like that. So with that in mind, I pose the question, do we think that framing that harm, the notion of harm, is a suitably solid base to begin conversations about legislation? Because in my mind, for example, I think that it draws us into a gray zone that might not have the clarity and precision that would allow for due process in the instance in which, for example, content was deemed harmful under the white paper system, then you might have insufficient grounds or documentation to be able to appeal this decision or to be able to follow it through the legal system. So I'm just wondering what the panelists might think about this. Is this actually taking something that is insufficiently clear and then trying to build legal frameworks on it?
I'll just say something very brief in response to that. It's just to go back to something I was actually saying to the EuroDIG participants the other day, which is that I think some of the maybe not most violently harmful, but probably some of the most broadly harmful online content that we see, perhaps doesn't even come from a malicious or even necessarily greedy place. It comes from perhaps a misunderstanding or a development of what people are trying to do that they weren't aware of previously. And I think your point speaks a little to that, in that how do you actually regulate that? It's very much a sort of backwards-looking attempt.
I think the question of what is good and bad is very difficult. And that's partly why the duty of care proposal that I put forward tries to sidestep it somewhat, so that it's not trying to define very, very closely how bad something is. What it's looking at is how you get to that harm, broadly speaking, and whether the social media platform has thought about it. If I go back to my analogy of the real world, if there is a floorboard up in a building, somebody who sees that wouldn't think, oh, is someone going to twist their ankle or break their leg because there's a floorboard there? What they would see is some sort of quite broad idea of risk, of harm. And they'd probably get a hammer and knock the nails in. So I suppose I'm trying to say focusing on process, because the idea of harms, especially when we move away from perhaps things that are clearly harmful, like child pornography, that you do get difficulties in definition. So it's trying to shift are we thinking about this? I mean, Facebook famously was moving fast and breaking things. And I'm not sure that's a responsible attitude. So it's sort of thinking, what am I going to break? Or what am I likely to break? Rather than just moving fast.
Yes, as a lawyer, I also agree that if a term is a bit ambiguous, it will be really hard to create a whole legal system based on this notion of harm or online harm. But also I think that another underlying aim with this new wave of a fight against online harm is that we want to change the community rules, which, as I said, in my opinion, were not created by the community at all, but were imposed on the community and not necessarily reflect the values of the community. And with this, in long term, I think we will achieve the shift in the mindset of also the the technical community, for instance. And I agree with you a lot when you said that we also need to talk with the computer science people, because, for instance, I have friends that are that work in the IT field, and our perception of things is completely different. But when you communicate and try to understand different perspectives, there is a shift, and they are building their, for instance, applications, and they consider these privacy issues now. So I think it goes a long way, and that's just a small effort. But if everyone works towards that goal, then in maybe long term we will see some shift. So.
Excellent. Now I see we have a question here. Yes, please.
Yes, good afternoon. My name is Mark Hoogwoning. Full disclosure, I'm a colleague of Chris. I also work for the RIPE NCC, but not necessarily here to reflect that position. Sharing an observation that I also made earlier in the workshop, and I would love to hear the panel's responses, and picking up, it's two connected things, but as one of the panelists mentioned, we need AI, we can't do this with humans, and I hear that more often is, yes, we need technology to rein in the technology, and extrapolating from that, and that's also something I heard echoing, basically starting yesterday with Maria Gabriel's speech and several other places, also in the UK white paper, is self-regulation has failed, so we must regulate. But we're kind of stepping up to a point where we're quite possibly need to regulate self-regulation. And my feeling is that we're kind of coming into a circle with technology controlling technology and stacking layers of regulation. How far is that controlled? What do we do if the next regulation, if the UK white paper fails? If the regulation of self-regulation fails? Aren't we sort of at a never-ending story? I would love to hear the panel's reflection on that. Thank you.
Okay, I'll start then. No, thank you very much. Perhaps in between there is something that is called co-regulation. To have a legal framework, and the legal framework, as Chris rightly pointed out, largely exists. I mean, there are very clear legal standards. We don't have to invent a ban on child pornography. It exists in our countries, right? And that's also a form of harm, which is, of course, easy to identify. The more problematic areas are the ones that are in the middle, where it's not immediately clear whether it's harmful, but it may be harmful. So I think co-regulation is important. The responsibilities that industry takes, but also the responsibility that the state takes to intervene where necessary. And there is, in law-abiding democracies, there is a judicial system, there is a court system. It's ultimately also under the treaty I mentioned first, the Convention on Human Rights. It's finally up to a court to decide whether or not there is a breach of freedom, either an unjustified or a justified interference with freedom of expression, and whether or not some content is harmful and needs to be taken down. If such a decision is taken, then of course it's vital that that decision is complied with as rapidly as possible. But I think co-regulation is perhaps the best way forward.
I can say something about the white paper again. I feel I'm droning on about the white paper, but that is my purpose here, I feel. I suppose you could describe the system envisaged by the white paper as a form of co-regulation, because it envisages a framework set in legislation at quite a general level, but then there will be a role for a regulator to develop more detailed codes of practice. And in this, I think it's envisaged that various stakeholders get involved, so that will be the technical community, but I suspect also civil society and various interest groups to try and counter some of the problems you get with devolved standard settings, which is that they sometimes can get, not necessarily deliberately, but they can be hijacked by those with the expertise. So I suppose that is a form of co-regulation.
Excellent. We had the first question in the back, but I'm not sure if the microphone works there.
Testing?
Yes, perfect.
Yeah. Hello, panel. My name is Alex Brown. I'm an academic at the University of East Anglia, just up the road from Professor Woods' university. So my question is about public spaces and the idea of a duty of care being an appropriate metaphor for public spaces. I'm wondering how far or how much of the internet that can really cover, because some internet companies seem to be in the business of providing semi-public or semi-private spaces. And to use a metaphor analogy, take swimming pool provision. Suppose you're a public body offering a new public swimming baths for people. You'll set down some rules, no heavy petting, no bombing, and you'll have a lifeguard on duty to make sure that the rules are followed. Now imagine you're a private luxury hotel offering a swimming pool. You'll also probably put up some rules on the wall, but you, generally speaking, don't hire someone to sit there as a lifeguard. You allow your patrons to kind of take their own risks, and you feel you've done your safety bit merely by having signs on the wall. You know, pool is only 10 foot high at this point. And I'm wondering whether that tells us something about how far duties of care can go, or how it can be interpreted for different internet companies.
I guess that one's for me, is it? I'm glad you gave the example of a swimming pool, because there is actually, from the Health and Safety Executive, which is the regulator that enforces the Health and Safety at Work Act, there's an entire guidance sheet on what you have to do to make swimming pools safe. But there is a good point you make, which is about proportionality and a risk-based analysis. And I suppose we started talking about the duty of care in the context of public space to make it talkable about, to move away from publisher intermediary. And so at some point, I think we let go of the analogy. We have said, and I think you also find this in the white paper, that when you are looking at the duty of care, and because you're looking at process and risk, it will vary depending on what the nature of your virtual space is. So that if you are, sort of aiming at children, I would expect there to be much more stringent safeguards, tools and what have you, than if you are looking at a site that's aiming at, 18 to 24-year-olds. So yes, risk, and different service, different nature of service, different ways it can be used, all should be factored in. It's not a one-size-fits-all approach.
Okay, you have some comments? No? Before we go to the next question, I would like to go to the online moderator and ask if we have any questions from the online community.
Is this on? Okay, perfect. Yeah, there has been a question from Arnon, and he's asking, so Chris Burke mentioned that his work is only the framework upon companies are built upon, which content is built. Facebook also said they were a framework, and now they find themselves in a rather precarious situation in relation to content moderation. Is there a risk or possibility where this extends to your work? Was it clearly understood?
I think so. I think there's definitely a risk, and it's why I'm probably sitting on this panel. No, I think when I make that point about the different levels, and we often use that sort of hourglass model of the different layers of the internet and how they're different. It oversimplifies things. It doesn't. The situation in reality is certainly much more complex, and I think you do see some discussions fall back on, no, that's sort of the structures and the architecture that actually makes it good, so we can't mess with that. When I say there's law there in place and that's what we should turn to, there are still obviously cases, and this is the basis of internet governance, I think, where the internet structures, the principles of the internet, the fact that it's cross-border, it's global, present certain challenges to laws and the way we make laws or have historically made laws. So I think you're always going to have to find the balance there, and we can't sort of rule out, the internet infrastructure or architecture is sacrosanct, that can't be touched. If nothing else, that's constantly evolving as well, for good and for bad. Driven by different processes. So that's where sort of awareness on the part of regulators and on the part of users of what that architecture actually is important and is significant.
Let's collect both of the questions, considering we're running out of time, and I know our dear speakers have to catch flight. So let's have both questions. Here you go.
Okay, so my name's Adam Kinsley from Sky in the UK. We've heard some of the challenges of trying to build a regime by maybe asking some challenging questions about what might be a harm specifically, how do we ensure that we're not impinging on human rights, etc., etc. And I just wanted to offer an observation that through the process in the UK, which was a government green paper and now white paper, actually what's happened is there's been a really broad conversation over the last 18 months, I guess, and the work that Lorna's done and others have done in the UK has actually led to quite a broad consensus that people are now saying this idea of whether you call it regulating the self-regulation or looking at the processes is actually the way that this can be achieved with an independent regulator that's governed by principles of proportionality and risk-based, but with sanctions ultimately. And it's just really interesting how everybody has come together, and I expect that it won't be seen as that controversial, given it's a very novel, groundbreaking piece of regulation. And I just wonder if this sort of dialogue can happen more broadly across other countries and other member states.
Well, I would like to continue the previous question, and also, as Chris mentioned, internet is cross-border. And well, I think it's EuroDIG, but not European Union DIG. In this region, there are already countries with online harmful content regulations: Ukraine, Belarus, Russia, whereas on regulatory minefields, mines already set and detonating under the feet of operators, of companies, of independent media, of freedom of speech. So, unfortunately, I don't know why, well, such examples are not involved in this discussion. Looks like everyone discussing online harms white paper from United Kingdom. But if you look at that paper and you look, for example, on Russian regulation, then all censorship is performed on the name of protecting children from online harms. Why such cases are not studied? Why such cases are not brought up? Internet have global things. And while talking to European Union, for example, LGBTQ information in Russia could be considered as harmful to children. While I think here in Netherlands, such information could not be harmful at no cost. So how do you study, well, especially European officials, examples of bad regulation, unsuccessful regulations, and law applications in other European countries?
Thank you very much for that observation. First of all, we're certainly not speaking about just the European Union. I mentioned, I think, a few times, the Council of Europe is 47 countries. It includes all the countries you mentioned, apart from Belarus, which is the only country not a member of the Council of Europe, but all 47 other European countries are. And I also mentioned the European Convention and Court of Human Rights. There are cases concerning regulatory frameworks. In the Strasbourg machinery, there are very few decisions so far, but there are a number of cases that have been brought and that are currently under consideration by the court. So watch this space. We will see.
I'm definitely aware of this, but this panel is not discussing, this community is not discussing these cases. I'm aware, you are aware. Why we are not bringing this up, especially you sitting at the stage?
Well, I think the first thing I said at this panel, I think, was drawing attention to the European Convention on Human Rights. So I don't think I can be accused of not having brought that up. And I also said it's for courts to decide. We have so far relatively few cases, but it's also true that it takes a while for cases to be processed because there has to be exhaustion of domestic remedies. So the cases have to be first judged by the highest national court in the countries you mentioned. But I know there are a whole series of cases pending. That's why I said watch this space, because we'll see in the coming months, and certainly before the end of the year, a number of cases coming out of Strasbourg where the court will decide whether or not the regulatory measures are in conformity with human rights law. I must also apologize because I'm one of the people who has a very limited possibility of connection, so I will have to leave you now.
Thank you very much for being with us. Any more comments about the questions that we had? No? No? Okay. If nobody else wants to raise any more concerns or questions or comments, I would like to conclude by inviting our dear rapporteur, Cedric. Would you like to read the messages?
So I'll just move up here. My name is Cedric Aim. I'm working here with the Geneva Internet Platform. And as you've seen throughout the conference, we have been in charge of putting together these little messages, trying to sum up and have somewhat of a forward-looking outlook on the topics discussed today. So the first point that I have mentioned was identifying the scope of online harms as well as having a clear understanding of the terminology are crucial in order to allow for the right responses to be taken. These include regulatory measures, example given such as legal frameworks based on self or co-regulation, and the fostering of digital literacy. The second point is, it is important to not only look at how to develop new laws, but rather it is necessary to consider existing regulations and human rights frameworks by which content and online harms can be evaluated and enforced. And finally, we must not overlook the less visible and more difficult to identify issues such as cyberbullying or the outsourcing of content filtering conducted by humans. So the final question I would have is if there is some strong disagreement with these key messages. I see none. Thank you very much.
Perfect. That's very great. So nice audience, agrees with everything. So today we tried to address how the future could or should look like in terms of tackling illegal and harmful content and activity online. However, we must remember that our online community is just as real as offline community. And we should be working together to make it a better place. So I want you all to thank you very much for the discussion, for the debate, for the comments and concerns raised. And just to end the session, I would like to express my deep gratitude for the key participants, to Professor Lorna Woods, for Jan Kleisen, who had to rush off to the airport, Chris Buckridge, thank you very much, and our EuroDIG fellow, Mary, thank you so much. And of course, this would not have happened without the organizing team, without the EuroDIG Secretariat. Thank you for the support and the contributions. Also Fabio, the moderator, online moderator, and Cedric, the rapporteur. And I finally would like to thank the audience who are so active. And it was a true pleasure. So thank you very much. Yes.
Thank you.